Steve Shamrez, Patrick Hafferty joining us to talk about this case, and you guys have been speaking about this on the news at 6. We've been talking about it in the morning. What does it tell you that it took them a very short period of time to come up with this verdict?
It's easy to say this now, but the reality is this was a result that was identified as likely early on. The police, law enforcement did a massive investigation. They invested massive resources into collecting evidence and attempting to identify all the relevant information. And the prosecution did a really good job of laying it out for the jury, and the jury was convinced. The defense did what they could in terms of trying to poke holes in the state's case. But the reality is the jury very quickly decided the state had proven its case beyond a reasonable doubt.
There were a lot of moments in the course of the trial. We sat there and spoke about this on the news at 6, where we were wondering where the state was going, because we saw so many pieces of evidence that did not seem conclusive in any way. And then yesterday afternoon, Ian Vance Curzan took to that podium and sewed it all together in about a 30-minute speech with visual aids and maps, and he showed clips of video, and it really did wind up telling the story of how Maxwell Anderson did what he's been convicted of doing.
That's right. As you say, if you sort of get down in the weeds, sometimes you look at what a prosecutor or defense lawyer is doing and you think, why are they presenting that? Why are they saying that? Why do they have this witness up there? But at the end of this, the prosecutor really did a nice job in bringing it all together. And as you say, about a half hour, he really condensed this and told a story, and the jury obviously has believed the story.
A lot of people asked at the time when we saw yesterday, the defense not really presenting any witnesses, but it's not super unusual for that to happen. What is the thought process behind that? You just don't think that they've reached the standard of burden of proof of beyond a reasonable doubt?
So really there are two approaches that lawyers will take, defense lawyers will take during the jury trials. One is sort of the hole poking approach, which is what Tony Cotton did here. The other is offering an alternative theory. The defense here chose not to offer an alternative theory. I don't have the inside track on what information they had available or what strategies they considered. But the reality is, if you don't present an alternative theory, it's generally because you don't have one. And here there's still lots of information that the defense would be in possession of, the defendant in particular, about the location of some of the dismembered body parts, how this happened, why this happened, and he chose not to testify. So this may be information that the public just never learns about.
Are you surprised? You knew this was going to happen quickly. I mean, you told us yesterday as we were all preparing our plan for today, maybe 10:30 we have a verdict. The jury had this about 25 minutes in the afternoon, and all of
1 minute this morning.
1 minute this morning. 9 o'clock, we had a verdict this morning. Are you surprised it was that fast?
I'm surprised it was that fast, and I don't know why the judge didn't allow them to deliberate at least for a little while last night, but had she done that, this very well could have happened at 6:30 or 7 o'clock last night if they had been given a little bit of time. With that said, the jurors were there for 2 weeks listening to this evidence, and they clearly paid close attention. You could see lots of them were taking notes, and they were confident in their decision.
What do you know about what happens in the jury room that they decided, you know what, let's not take a vote tonight? Was it, let's all sleep on this, make sure we're good with God, and and our decisions here, and come back in the morning and get it over with?
That may have been. There's no public information about the conversation that the judge had with the jurors, but they may have told her, hey, we're tired, we want to sleep on this and come back tomorrow morning. She may have just said, look, we're not going to keep the courthouse open late for this. She may have expected that they were going to take longer than they did. They probably picked a 4-person last night, and then were told, hey, you're going to head home and come back tomorrow. And they came back, they were well rested, they had digested the information, and they rendered a verdict.
What happens next? So this is a first-degree intentional homicide, carries with it a sentence automatically, right?
It's a life sentence. Theoretically, the judge could set eligibility for extended supervision, which is like parole, after 20 years. But keep in mind, he's got life plus all of the exposure on those other 3 counts. I think 2 of them carry up to 12 and a half years. 1 carries up to 3.5 years. So the likely result is life plus 25 is what he's going to end up with. I'd be shocked if this judge were to make him eligible for extended supervision, given the gruesome nature of all of this.
And they did have the option for lesser included, right? Which meant they could have found him guilty of a lesser charge.
That's correct. The first degree intentional carries a lesser included first degree reckless homicide. With that said, that's still a 60-year exposure. So it's sort of a Pyrrhic victory to end up with the reckless homicide. It's going to result in a life sentence regardless.